So, dear friend, recently, and rather I would say yesterday only, an incident of sharing of child pornography has been reported widely in the media as well as the social networking website, where few boys were sharing the data relating to the various minor girls in a group formed on the Instagram. The incident is a very serious one and has the serious repercussions. So we are going to discuss about what are the offenses it attracts and who are the parties who are liable and how we can initiate the relevant proceeding in such a case. So let me share my small presentation of this. So, friend, we are going to discuss about what would be the liability of the person who have participated, either as sharing the content, forwarding the content, or the person who are part of the same group but who claim that they are not the active member, and what would be the liability of the administrator. Then we are going to discuss about what is the liability of the Instagram, whether Instagram has any liability in the present incident? If yes, what the liability is. Then we are going to discuss about the role of the, make a distinction between the role of the police and role of the publishers. Publisher is the person who has posted the content. So let us briefly discuss about the incident. And the incident is that a group was active on the Instagram named Bois local group, on which the participants were circulating the photographs of minor girls. And some of these photographs were stated to be the morphed photograph, and the various member of the group, participant of the group, were making the comment, sexual comment on the photographs, vulgar comments on the photograph, and comments such as committing or attempt to commit the gang rape, and also body shaming comments. The group which had been created on the Instagram was a fake group, and it was also being stated in some of the media that thereafter few other similar group was created in the Instagram. So first let us understand what the offenses mean. So when we talk about pornography, child pornography, so first thing is the offense of child pornography is made out because the minor whose photographs were exchanged. Second, because of the fact that it has been delivered to the person who are also the minor. So basically there are two components: photograph of minor and conveying and publishing the information to the minor. So it constitutes the offense of cyber pornography from two particular perspectives. Right? So first of all, the offense would be made under section 13 of the POCSO Act. So POCSO is a specific legislation which is aimed at prosecuting the offender relating to the crimes committed with the children. So first offense is made out under section 13 because the images of the child, images of the minors have been used for the pornographic purpose, and indecent or obscene representation of the minors have been done in the said group. Punishment for the same is up to the 5 year and also fine. Then, apart from the POCSO, the child pornography is the offense which is covered under Information Technology Act 2000. And under section 67B of the Information Technology Act, it is also a criminal offense. Both in way, creating any material relating to the child. Second, conveying any material to the child with a sexual intent. So from both the angle, the offense is made out. Third, the offense which is also incidental to it because the group is fake. Second, some of the participants have created their identities by the fake news. So that then section 66 of the IT Act would also be attracted, which is also a cognizable offence with the punishment of 3 years. Then now we need to understand that there are two types of pornography: child pornography and adult pornography. One thing is, as far as the adult pornography is concerned, its possession and its possession is not offense. And second, if any person see, visualize the same, it is not an offense. But as far as the child pornography is concerned, looking upon the child pornography, circulating it, possessing it is an offense. And under section 21 of the POCSO Act, there is a specific provision: if a person comes to know about it, and the person include any school, any hotel, any entity, any organization, any company, also include the service provider, Instagram. So if a person comes to know about it, he is duty bound to report it to the police. And if he does not report it, it is a cognizable offense. Then coming to the basic crime. What is the crime which is committed? Number one, the crime which is committed is, number one, publication of the obscene material by the publisher, the person who has transmitted it. Second, by the party who causes it to be published, who facilitated it. And that party would be liable to be prosecuted as an abettor under section 109 of the IPC. And in the present case, the party is the Instagram. So both are liable. But section 79A of the Information Technology Act provides the immunity to the internet service provider from the prosecution, provided two conditions are satisfied. The condition number one is that if that party preserve the evidence and provide it to the police as and when required. And second is the metadata regarding that particular evidence. So if they do not provide and they do not comply with the notice and takedown approach, for example, the moment it comes to their knowledge and they have not removed it, they would be liable to be prosecuted. So under section 109, Instagram can be prosecuted for it. And any other person who does not inform, that person is liable to be prosecuted under section 21 of the POCSO Act. So that's why any member of the group, whether he is a active member or non-active member, and also if he is an administrator, all are liable to be prosecuted for the offense. So a person who claims that I am an inactive member, he does not have any immunity from prosecution. Now, from the various media, it has been reported that the offense has been registered under section 66A of the Information Technology Act. Here I would like to add that section 66A has already been declared as unconstitutional by the Supreme Court in the year 2015 in the judgment of Shreya Singhal. So that section cannot be invoked by the police as of now. Right? And under under the provision of POCSO Act, police is duty bound to register the offense under the POCSO Act only. And if they do not invoke the POCSO Act, they are also liable to be prosecuted under section 21 of the POCSO Act for the offense, which is with a punishment of 6 months. Now coming to the another thing, that if it is a child pornography, then the person who has even shared the images from that particular group in the social media, whether that particular person has any liability, to answer is yes. Because when the material is obscene, material of child pornography, any person who forward that material, who share that material, is also liable to be prosecuted as an author of that obscene content. The only intention would have been if that person, instead of sharing it with the social media, would have shared it with the police, would have shared it with the court, and have used such content only for the purpose of making a complaint and no other purpose. So in the present case, that person is also liable to be prosecuted. Now coming to the issue that the offence has been reported in the media and nobody has come forward to file the complaint. So here I want to clear it that as far as the obscene content is concerned, any person can file a complaint who have seen it, read about it, or heard about it. So any person can file a complaint. So he need not be a person who has received the data, who has received such pornographic material. Instead, Section 21 says that any person who has come to know is duty bound to file the complaint, failing which he is liable to be prosecuted. So, friends, I think this is one of the serious offense which is required to be prosecuted if we want to protect our children from such incident in the future. So, I have given you the information about the law which is applicable on it. And if you require any further information, you are always welcome. You can send me email. You can also contact me through my social media contacts. And thank you again for approaching me to get to have my views on this particular issue. Thank you. Thank you very much.